Hello and welcome to The Pulse, our weekly show where we discuss issues concerning people and the society. I am Tina Jha. On the 15th of July, the Supreme Court issued a notice to the centre on a petition challenging the validity of certain provisions of the Medical Termination of Pregnancy Act, which disallow abortion beyond a certain period of time. The plea, filed by 3 women, contends that the provisions that allow abortion only to save the woman's life or in case of abnormal fetus violate women's right to health, free reproductive choice, her personal liberty, privacy and bodily autonomy. And that's why they've urged the Apex Court to declare these provisions under the MTP Act as void and unconstitutional. Before we move ahead on the program, let's understand what the MTP Act says and which of its provisions have been challenged in court. So under the Medical Termination of Pregnancy Act 1971, abortion is a qualified right. But the procedure can only be performed by a registered medical practitioner for up to 12 weeks of pregnancy. And beyond 12 weeks and up to 20 weeks, the opinions of 2 medical practitioners are required. An abortion is permitted only if continuation of the pregnancy poses a substantial risk to a woman's life or her physical or mental health, or if a pregnancy is caused by rape, or if the fetus is suffering from either physical or mental abnormalities, and if the pregnancy is due to the failure of contraceptives, but this clause is applicable only to married women. However, beyond 20 weeks, termination of pregnancy is not admissible under any circumstance. So in such situations, pregnant women seeking abortion are left with no choice but to run to courts. In the year 2014, the government did propose to bring the MTP Amendment Bill. It sought to extend the permissible period for abortion from 20 weeks to 24 weeks if the pregnancy involves a substantial risk to either the mother or the child. And in case substantial fetal abnormalities are detected, the amendment sought to allow an exception on the time limit for pregnancies to be terminated. However, the bill is yet to see light of the day. So although abortion has been legal in India for nearly 50 years, it cannot be conducted merely at a woman's request. And because it recognizes only situational reasons as valid for abortions, it in a way contributes to increasing number of women seeking terminations from backstreet providers. Research shows that unsafe abortion is the 3rd leading cause of maternal deaths in the country, contributing 8% of all such deaths every year. A staggering number, about 15.6 million pregnancies are terminated yearly in the country, which means 13 women die every single day owing to unsafe abortion-related issues. So will liberalizing the MTP Act bring down the overall maternal mortality rate in the country? Will it ensure access to safe abortion to the women of India? And is changing the law on abortion enough? These are some of the questions we'll try and find answers to on this edition of The Pulse. Joining me on the show today are Dr. K. Aparna Sharma, Associate Professor, Department of Obstetrics and Gynecology, All India Institute of Medical Sciences. She also works in the area of fetal medicine. Beside her is Dr. Shanti Olak, Chairperson and founder of Muskan NGO. She works with persons with intellectual disabilities. Next to her is Sanskriti Pathak. She's an advocate, and she's the one who's filed the petition on behalf of the 3 women who have challenged certain provisions under the MTP Act in the Supreme Court. And we're also being joined on the show by Mr. Swati Agarwal. He's former Secretary, Ministry of Women and Child Development. Thank you to all the esteemed panelists for joining us on this edition of The Pulse. And besides, we're also being joined by some members in the audience and from different age groups. So they'll be putting forth their viewpoints on the subject as well on this edition of the show. Sanskriti, let me begin the show today with you. Because you're representing the 3 women who filed a petition challenging the validity of certain provisions in the MTP Act, help us understand what are the main contentions that you have with the plea, considering also that India is one among the very few countries where abortion is legal.
See, basically we've challenged 4 basic premises and 4 basic provisions in the Act. So Section 3(2)(a), that deals with the first trimester pregnancies. So if a lady in India wants to get an abortion in her first trimester, the requirement is that the doctor, one medical practitioner, has to come to an opinion that either the pregnancy will lead to some physical or mental injury, or there are certain fetal abnormalities, or there is a risk to the life of the woman.
Okay.
So studies show that first trimester pregnancies are very safe. There are significantly very less risks involved if you compare it with the full-term delivery. So far as first trimester is concerned, what we are saying is it should be on the request of the lady. These conditions should not be there because that's an undue burden on a reproductive choice. And then, so far as section 3(2)(b) is concerned, which limits it to 20 weeks, these grounds certified by 2 medical practitioners, but the time limit is 20 weeks. What we have prayed before the court that this 20 weeks should be increased to 24 weeks because the medical literature says that till 24 weeks the abortions are safe. Obviously you will have stray cases, but we are not dealing with stray cases. So that is the second challenge. The third challenge is that unwanted pregnancies, they are taken care of by the MTP Act. Unwanted pregnancy due to contraceptive failure is only available this ground is available only to married women. Unmarried women don't have this benefit. So it's discriminatory, so it should be made available to unmarried women too. And the last provision that we have challenged is section 5, which permits abortion after 20 weeks, but the only ground which is available is to save the life of the woman. So as we are seeing cases every day, we read that some rape victim or some lady had to come to court wherein there were certain fetal abnormalities discovered at a later stage of pregnancy, but they have to come to courts for that because it's against the provision of the Act. Sometimes they get relief from the court, sometimes they don't. So what we have said that this ground saving the life of the woman is too narrow. It should accommodate certain other grounds like fetal abnormalities, physical injury to the lady, rape victim. So all these grounds should be accommodated to make it constitutional.
Okay. Dr. Aparna Sharma, let me bring you in here. One of the key contention in the petition filed by 3 women in the Supreme Court is to raise the cap from the current 20 weeks to 24 weeks. Now, as a doctor, how will raising this cap help? Will it help solve a lot of problems?
Yes. So, I would like to mention here that, science has really advanced now, and as an ideal antenatal practice, what we advise is that the first ultrasound should be done at 12 weeks, between 11 to 14 weeks. Like that's the first scan that it should be done. And but that's an ideal practice. But one essential scan that needs to be done is at 18 weeks, right? So, because by that time we assume that most of the baby is formed. So, if a woman is actually getting some ultrasound done by 18, 19, so ideal practice does not exist. So, most of the women get their first scans done around between 18 to 20 weeks. Now, if by chance she detects something like acrania, that means the head itself is not formed. And we come across such cases so often, because the lady had no contact with a doctor till this time. At 5 months, they believe, okay, I will go and get an ultrasound done, and the baby's head is not formed, right? So, in that situation, she's already 20 weeks. So, MTP law, even the head is not formed, will not allow a termination of pregnancy. But in the present day and age, with the safe abortion techniques which are available with us, so if you stretch it by, say, just 4 weeks, make it 24 weeks. So, first, you have a bigger window. Also, even if the woman has done some tests around 18 weeks, she's done a scan, but sometimes we do not terminate at one scan. We need further tests which are called amniocentesis or chorion-villus sampling, which are called prenatal diagnostic techniques. All of them take like something like 10 to 12 days to 2 weeks for the reports to come. So, at least give the parents a choice, give them time to breathe. The moment a 19-weeker comes to us with some abnormality, the whole unit is, running that do quickly before 20 weeks.
And is termination of pregnancy completely safe in 24 weeks?
Yes. So, between 20 to 24 weeks, there's not much of a difference, not to the mother or to the baby. And also, another very important thing that we have to know is the commonest abnormality in a fetus is cardiac abnormalities. It is the most common abnormality. Yes. The fetal heart cannot be done ideally by normal radiologists who are not fetal medicine people easily before 20 weeks. An ideal cardiac scan is done at 22 weeks, right? So here there is no option of looking at the heart, because anyways you're not going to terminate, right? So these are some of the medical, principles that really say that, if you have a window of 4 more weeks, you give the breather to the doctor, to the patient, and, benefit people at large.
Mr. Agarwal, you agree with her because she says the right to choice should be given to the woman, and by raising the cap from 20 to 24 weeks, a lot of problems will be solved. Perhaps because our law was made almost 5 decades ago. And do you agree with the point that, it is time that we amend the law?
I entirely agree with her that the choice should rest entirely with the woman, with the mother. And up to 24, I personally feel, as long as the child is safe, the mother is safe, there should not be any problem or there should not be any question of even consulting a medical board or a doctor. After 24 and maybe up to 32, we can have some kind of a medical board which will say, yes, it is all right to terminate the pregnancy. And thereafter, there can be certain law that it cannot be done, etc. But till 24, the entire choice should be available to the woman.
Okay. Perhaps when in 1971, when the MTP Act came into being, the right to choice was missing from the Act. And now, in 2019, we must incorporate the right to choice and should give it to women. Perhaps as a woman, I should be the one taking the final call on whether I want to continue with the pregnancy or not.
No, I agree with the right to choice for the woman. But the conditions, they work as a larger value system within which a human act is justified or not justified. But largely I would say that as a right, a woman, if up to 24 weeks, the termination of pregnancy is safe, then the woman should have the right to choice.
But you work with persons with intellectual disabilities, if this right to choice is given to women, it's an absolute right if the law is amended. What about the right of the persons with disabilities? Because if every mother decides to discontinue with the pregnancy in case of an abnormality.
That will happen if the law permits it even more. You see, I have a very different view about it. The way human mind works, we want everything to go perfect in our lives. And in pursuit of perfection, we only see our life and do not respect the lives of other people, do not value the lives of other people, because we are in pursuit of some certain kind of perfection, and that happens very naturally for children also. So, what I feel is that unless it is a condition where the child is not going to survive with full-term delivery, the choices should be available to the mother. But abnormality itself should not become the ground for termination. The reason being, you see, what should happen rather that one can acquire certain kind of disability with normal body and mind also. So the society has to be sensitive to the needs of the vulnerability of people and provide opportunities, provide services for that, rather than, you see, banning them to come into this world and enjoy this world.
Let me come back to you, Mr. Agarwal, once again. Another provision that's been challenged is that in case of contraception's gone wrong, the clause allows only married women to terminate their pregnancy.
It's a ridiculous clause. Ridiculous.
So does this need amendment?
Absolutely.
Should unmarried women and single women be also allowed?
We should not make any distinction between a married woman and an unmarried woman as far as the pregnancy is concerned. It is her choice, and as long as this pregnancy is because of not functioning of the contraceptive, the choice should be with the lady. And she is a conscientious person. She understands what is wrong and what is right, and let her exercise the choice.
Dr. Sharma, help us understand that, despite the law, despite abortion being legal, although it's a qualified right, it's been legal in the country for close to 50 years now. Despite that, why is the rate of unsafe abortion so high in the country?
So, I think the unsafe abortions are happening because number one is, a lot of social issues also, but let's just talk about the medical part first. So I would say that, so yesterday, like suppose a patient comes to me, right, and she says she's just 21 weeks, 22 weeks, and I say, law doesn't allow me, I will not do it, right? But, the next door person who's maybe the center is not maybe, validated. A lot of places, see, abortion, they say that, number one, it's the availability of over-the-counter drugs, right? So I'm not saying that the drug should not be available, but it should be taken under supervision, which is the most commonly missed situation. So first trimester, let's go by first trimester and second trimester. So what happens in first trimester is that, you do not have a validated abortion place in your close vicinity. So she just goes to any quack or, anybody who's maybe prescribing her a medical abortion. Now they say that, unwanted 72, just go and take. Then what happens after that? Was that an ectopic pregnancy? Did it actually lead to complete abortion? Were there some retained POCs? Did it lead to incomplete abortion? There's no follow-up on that. So what happens is that there are some retained POC or maybe she bled excessively. So number one is that the protocol for abortion is fixed very beautifully by Government of India. You take one drug, after 2 weeks you have to do a scan done. Before that, definitely you would want to know at least by an examination that it's a normal pregnancy and the pregnancy is not outside the uterus. So there are certain prerequisites. So a visit to a doctor is essential. But over-the-counter drugs and by, who are not registered, by administration of these drugs by people who are not registered. Also centers which do not have the facility to do safe aseptic precautions, procedures with aseptic precautions. So these are the reasons why mainly unsafe abortions are occurring. Also, the thing is that especially for second trimester. Now, second trimester abortions, let me tell you, are a little tricky in the sense that they need to be monitored very nicely if you do not do it. So if I refuse a 22-weeker and she goes somewhere where the people are not actually, qualified to do that, so that again leads to unsafe abortion. So abortion facilities should be widely available, government approved, or at least in our country everything, because obviously private sector is a huge sector. So whatever it is, the cost factor, going to a center is costly, so maybe they'll go to a place which is, not very well equipped. Then it should be widely available. And then again, especially in cases of unmarried women, the judgmental behavior. So I think as a society we need to come up against that, right? I know that even now, if an unmarried girl walks into a clinic, people will actually judge, okay, you are unmarried and you're pregnant. So somewhere those hesitations, so she will go to a place which is very, very nondescript, where abortion clinic is not written at all and some backdoor thing is happening. So these are some of the social issues that we need to really get aware of, and definitely the better availability of abortion facilities in terms of awareness and also equipment.
So a lack of awareness, social taboo in a society where we live in, girls, women are not very comfortable. So Sanskriti, in such a situation, in a society that we're living in, will legalizing or liberalizing the current act, will it be enough?
Of course, see, only striking down these provisions of the act, that's not the end to the entire problem. So these are systemic issues which will involve more measures like having more doctors. Paucity of doctors is also one of the reasons why medical facility is not available to people in rural areas, people from marginalized sections. So everything has to be streamlined. There are a lot of things, there are a lot of multi-pronged attacks which have to be made to this problem of unsafe abortions and this curtailment of reproductive choice.
All right. Let me also bring in some members from the audience.
Hi, I'm Shriya Mishra. I am a legal intern. So my question is, as it is, our sex ratio and fertility rate is depleting. So what impact, according to you, if suppose we legalize abortion? So what impact will legalizing abortion have on our society, and especially where the infrastructure facility, like diagnostic infrastructure facility is lacking in rural areas? So according to that, what effect legalizing abortion have in the rural areas?
We also have some other young women among the audience. What do you think? What's your viewpoint regarding the contentions that's been made in the plea filed in the Supreme Court? Do you agree with the contentions that have been made?
Hi, my name is Sanjana, and I think it's very important that women should be given the right to make this choice because it affects their body. But at the same time, I believe it should be limited. It should not be absolute because where do you draw the line then, right? And that would also lead to extreme cases. But I also have a question with regard to this same debate. I want to ask that when does the legal personhood of the fetus initiates in the term of pregnancy, and how does that affect the abortion discourse?
Dr. Sharma, would you like to take up that question?
Yeah, so should I answer the first one first?
Sure.
So first of all, as we discussed, that this act came in 1971, so it's like 50 years almost since the act. What has changed from them? It's not just the right to choice. It's actually medical technology which has evolved.
Yes.
Right? So I think we should not forget that and take advantage of that. Right? If you say that you will only abort till 20 weeks, you are missing out, especially in the rural areas where women for 3 months are not even aware of their pregnancy. They suddenly become aware of their pregnancy at 4 months or maybe 5 months, right? And then they possibly decide to go to a ultrasound, to go to a doctor. And if we do not give them the right to this abortion, then you are possibly taking away that advantage of that one early scan which she decided to, by chance she decided to do. So I think for the rural people especially, with the availability of these diagnostic modalities as you've been talking about, I think extending this from 20 to 24 is actually facilitating much more numbers of possibly, unsafe abortions, decreasing the number of unsafe abortions and, doing that step in the right direction without actually causing any harm to the mother, because between 20 and 24 weeks, the risk of abortions, they actually remain the same, right? And as far as your, right of the fetus is concerned, then I must say that this is something which is very, very, intellectual and, that kind of thing, because right now we are at sea regarding it. But technically speaking, you can talk about viability. The rights of the fetus in India, we are currently, unfortunately, not talking about it. But yes, there has to be a discussion about it. But we do talk about viability, and that is why we decide 24 and not 28 weeks. Right? Because when we talk about 24 weeks, you're talking of a baby who's less than 500 grams or something like that, who's not going to survive without help. I'm not saying of rare cases, rare cases will always, somebody will say, we had a baby who survived at 438 grams. I'm not talking about those. But in a general sense of the word, speaking like that, because WHO actually defines stillbirth at beyond 1 kg, right? So 1 kg is a cutoff when you feel that the baby might survive even without help. So at 28 weeks, the baby is 1 kg. So if you cannot say that you are aborting a pregnancy at 28 weeks, you are delivering a baby at 28 weeks. So somewhere the legality of personalization of a fetus or cannot be defined, but I would say viability is more of a medical and also a practical thing to take in hand when you're talking about such things.
When it comes to rights versus ethics, scientifically, she may say that, before 24 weeks, the fetus is not viable. After 28 weeks, you are practically delivering a baby. But, in a society like ours, where we believe the moment you conceive, there is life inside you. So practically and worldwide as well, there is this viewpoint. In America, there's something called the heartbeat law. The moment you have that heartbeat, you have a life inside you. And killing that is amounting to murder.
If you ask me, according to my values, I feel life is very precious and even potential life is to be respected. But seeing the kind of social situations in which all of us live, where there are many situations which may bring us to a situation where we have to decide whether I can take care or I cannot, or how the life of the mother is going to be affected by those circumstances, then I feel if the law permits up to 20 weeks and the medical science is saying that 24 weeks is good enough because of the medical advancements, so then I feel from 24 to 24 it should be extended. So my only ground is that the selectivity of abortion should not be determined by any other factor but the mother's health and mother's, life being in danger, or the child's life
All right.
being in danger.
Swati, coming to you, Dr. Aparna pointed out that, if the cap is raised from 20 to 24 weeks, a lot of problems are solved. We've had cases, last year there was a 10-year-old girl in Chandigarh who was impregnated by one of her uncles, and the detection was at a very later stage. So in a case where the pregnancy is detected at beyond, say, 28 weeks, in cases like that, where children are raped, but they do not have access to courts. So in a situation like that, do we require an absolute right where the doctors or the medical board decides and the pregnancy is terminated?
See, that is why I say that Section 5 is too narrow. All right, you've crossed 24 weeks. There is a situation of a rape victim. According to the law as it stands, you can't get an abortion done unless it is a risk to the life of the person itself. But you talk about cases where there is no risk to the life of the lady as such. In such cases, people have to approach courts. And the jurisprudence that we are developing, largely it's very progressive. Our courts are they're passing very progressive judgments. But then it becomes too subjective. It becomes case-to-case basis. And then we have to be alive to the fact that not everybody can go to courts.
Yes.
It's a fundamental right, all right, Article 32, it's there in the Constitution. But in practice, not everyone can approach a lawyer. And in pregnancy, each day counts, especially at these advanced stages. And the courts have their own, they act on an urgent basis in such cases. But we have examples like X versus Y, where Supreme Court took a very stern view of the lax behavior of the hospital and the court. So therefore, we can't leave it to case basis. This ground has to be widened.
Okay. Let me go back to members in the audience. आप बताइए कि कानून अभी जिस हिसाब से है, क्या उसमें परिवर्तन की ज़रूरत है?
मैं ये नहीं सोचती कि इसमें परिवर्तन की ज़रूरत है. एक टाइम पीरियड तक जब तक लेडी सेफ़ है तो इट्स ओके. अगर वो सेफ़ नहीं है, मतलब कि साइंटिफिकली अगर वो सेफ़ नहीं है तो उसका एबॉर्शन नहीं होना चाहिए. वो उसकी लाइफ के लिए भी ख़तरनाक है और बच्चे की लाइफ के लिए भी ख़तरनाक है. लेकिन आई एम वर्किंग एज अ फैमिली काउंसलर इन काउंसलिंग सेंटर, फैमिली काउंसलिंग सेंटर. तो मेरे पास भी कुछ केसेस ऐसे आते हैं. तो एक था कि वो एक लेडी आई मेरे पास जो लिविंग रिलेशनशिप में रह रही थी और उस समय उसके 3 या 4 मंथ की प्रेगनेंसी थी. लेकिन उसके बाद हमने एडवाइस किया कि आपको कोर्ट में जाना है, और वो लिविंग रिलेशनशिप में थी, उसके डिस्प्यूट हो गया था. तो अब वो चाहती थी मुझे बच्चे को अबॉर्ट कर देना है. और जब तक वो लीगल प्रोसेस में जाती करती और इन चीज़ों को समझती, तब तक वो टाइम पीरियड जो है वो काफ़ी बढ़ चुका था. तो उसके बाद में उसने उस बच्चे को वो बच्चा हुआ, डिलीवर किया उसने, और अब वो अकेले उसके साथ में मतलब पूरा सर्वाइव कर रही है, रह रही है, रख रही है उसको. तो उसके लिए काफ़ी टफ है. तो इन चीज़ों में कुछ लीगली मैं चाहूँगी कि इसमें कुछ जो कानून को कुछ लीगली कुछ एक्शंस होने चाहिए इसके लिए. कि वो अगर 4th मतलब कि कोर्ट तक जाते जाते तो वो उसकी प्रेगनेंसी इतना टाइम पीरियड बढ़ने लग जाता है कि 6 मंथ का हो गया, 7 मंथ का हो गया, वो उसको अबॉर्ट नहीं कर सकती है. और मतलब
क्योंकि आपने एक लिव इन रिलेशनशिप का एग्जाम्पल दिया है, मैं यंगस्टर्स हैं यहाँ पर, आपसे पूछना चाहती हूँ कि हमारे कानून में अभी अनमैरिड वुमेन के लिए प्रेगनेंसी टर्मिनेट करने का क्लॉज नहीं है. ये कंटेंशन रखा गया है प्ली में. अब कानून में ये परिवर्तन होता है या नहीं, ये तो देखने वाली बात है, लेकिन आपका क्या व्यू पॉइंट है इस पे?
हाय मैम, माय नेम इज़ अभिषेक पाल. मैम, ये कानून जो 1971 में आया था, जब एक कॉमन कंटेंशन चलती थी लोगों के बीच में, ओनली मैरिड पीपल हैव सेक्स और अनमैरिड नहीं करते थे. वो तो ऑब्सोलीट हो चुका है, अब तो उसको टाइम हो चुका है, पर्टिकुलरली चेंज कर दिया जाना चाहिए. जहाँ तक रहे 20 वीक से 24, आई सेड कि 30 तक कर दो अगर और भी कोई चांसेस. लेकिन आपको ये नहीं कहना चाहिए कि अगर कोई मेडिकल अनोमली होती है, छोटी से छोटी भी, और मदर और अगर फीटस को कोई ख़तरा नहीं है पैदा करने में, तब राइट नहीं होना चाहिए. तो फिर हम क्या करने जा रहे हैं सोसाइटी के साथ कि हम ये बोल रहे हैं जो वीकलिंग्स हैं या जो मतलब सर्वाइव नहीं कर सकते, तो हम क्या सर्वाइवल ऑफ द फिटेस्ट एक वो लॉ बनाना जा रहे हैं कि जो सिर्फ काबिल होगा वही आएगा इस दुनिया में. आने से पहले एक टेस्ट रख रहे हैं. तो वो 300 एक मूवी आई थी जिसमें स्पार्टा में वो आइकॉनिक सीन है, स्टार्टिंग में एक क्लिफ पे लेके खड़ा होता है और बच्चे को गिरा देता है कि ये फिट नहीं है उसके हिसाब से. तो क्या जो ऑटिज़म में है और जिनको डाउन सिंड्रोम है, क्या वो लोग सर्वाइव नहीं कर रहे? आज उनके मदर से पूछा, अगर उन्हें चांस दिया जाए कि आप ठीक कर सकते हो तो, और डॉक्यूमेंट्री में ऑन कैमरा कहती नहीं, मैं नहीं चाहती कि मेरा बेटा जैसा है वो सही है। तो अगर सिर्फ हम एबनॉर्मलिटीज़ के साथ चले जाएंगे कि हाँ कि कोई प्रॉब्लम आ गई है इसलिए अबॉर्ट करा दो, तो ये क्या चाह रहे हैं हम? कैसी सोसाइटी बनेगी उसके बाद हमारी, कि सिर्फ सारे नॉर्मल बींग्स आएँ? और इनके लिए इंस्टीट्यूट्स हैं, आप हेल्प कर सकते हैं, आते हैं, इनका एक पर्सपेक्टिव होता है, किसी का हाथ नहीं है वो पैर से लिख रहा है, बहुत सी चीज़ें जो हम कर सकते हैं, उन्हें मौका तो दें।
So it's the ethical dilemma that once again we are talking about, ma'am. But in this run-up to be ethically right, is it fair to, give birth to a life which will be full of suffering, even though it is minor? Because not everybody in the country will have resources to sustain that kind of life.
Suffering खाली किसी व्यक्ति की में कुछ प्रॉब्लम है, कुछ डिफ़िकल्टी उससे नहीं होती लाइफ में। सफरिंग के तो बहुत सारे सोर्सेस होते हैं, किन किन को ब्लॉक करेंगे हम? तो कि हमें प्रॉब्लम होगी इसलिए हम इस बच्चे को नहीं आने दें, या हमारी इमेज पे धक्का लगेगा इसलिए हम इन बच्चों को नहीं आने दें, दिस इज़ टोटली, इट जस्ट विल नॉट, इट्स नॉट अ हेल्दी एटीट्यूड. But at the same time, when we find, you see, so many people with all kind of difficulties that they have experienced, and the kind of courage, the kind of goodness in them is so inspiring. I have seen a person who did not have all the four limbs coming from Leh to Delhi for advocating the right. That person till today is inspiring me. So I don't think we should go into, you see, we should not tinker with these ethical values. What we should do is that whether that mother's health is in problem or the child's health is in problem, or other situations. For example, rape victim, as the family counselor said, living relationship. And I was just thinking that there should be some kind of a provision so that the man is held responsible. Not only mother, but the man is held responsible, and the man has to provide the necessary support to the mother to raise this child. So these things, this is how slowly we can improve the social fabric of the society so that everybody gets the needed justice.
But the kind of sentiment and ethicality that you're talking about, Dr. Sharma, is it something that we get to see in our society? If parents get to know that, the fetus, the child inside the mother is abnormal, even if it is a minor abnormality, would they like to continue? You're a doctor, you get to witness thousands of such patients. Is it the kind of sentiment that we are witnessing in our society?
Yes, so when I talk about this, I think, it is very much person dependent, the couple dependent, and we generally see a trend, that more and more couples, like, you are young, you're just gotten married, you have a baby who's got a minor abnormality. But they are not like, no, we want a perfect Einstein or, a Sachin Tendulkar, we want a perfect child. So they'll go for abortion. But at the same time, we have to understand that we do come across the other end of the spectrum who know that they have a Down's baby and they will still continue, right? So I think it's the society as a whole, everything has a bell-shaped curve. So like he said, he was very nicely, you put across your point, and we really appreciate it, that what kind of a society we are bringing in. But we, at the same time, laws cannot change society. True. The society makes the laws, right? A couple should have a choice whether to exercise it or not exercise it. We are a democracy. Just give them the choice, right? If a couple knows the baby has Down syndrome and yet at 22 weeks they have the option of abortion and then they don't abort it, that is the kind of society we are looking at. Because that kind of society will not discriminate a Downs when this is born. So we have to reach to that stage. But till that time, denying the right to abortion at 24 weeks, even when we have gotten to know it, when we know that the procedure is safe, is somewhere regressive.
But at the same time, Mr. Agarwal, by, giving the right to choice to the couple, are we not denying the disabled unborn child the right to live?
Ma'am, let's not get into the technicalities. First, I would like to answer his 3 questions. First was discrimination between the married and unmarried. I entirely agree with him कि अब कोई ये ज़रूरत नहीं है and ना ही it is desirable to have any discrimination between a married woman or an unmarried woman. Number 1. Number 2, if as the science has progressed and technology has progressed, instead of 20 weeks, it can be 24 weeks or 28 weeks. We have to keep it increasing as we progress. Number 2. And third, giving a choice to the couple or giving that choice to the society or to the lawmaker. I personally feel that it is the choice to be given to the couple or to the mother rather than giving this choice to the society or to the enforcement agencies. Not required, not desirable, not enforceable.
Okay.
The moment you do that, there will be so much of infirmity, there will be so much of corruption, there will be so much of discretion at the level of government agencies, enforcement agencies, and a whole lot of people. And why do we think that we are wiser than the couple? They are getting affected personally. So they know exactly what is right and what is wrong for them. Let them decide. And ultimately, at best, what I feel should be done, that they should be counseled. And there should be 2 or 3 counseling, maybe one day, after 2 days, or after 3 days, something like that. And thereafter, let them take a call.
In a situation like this, every parent decides
Absolutely.
to abort the
But
child.
they must be counseled. Okay, whether it is desirable, not desirable, ethical, unethical, but final call has to be taken by the parents.
I would say, you see, as one of the panelists say, whether law changes the society or society changes the law. I think law is providing overall value system also. So, in law, if we introduce this kind of element that if the child has some abnormality, but he or she would survive, she can live very well, then in that case there is no limit. I mean, where we are going then? Then we would be having only the perfectly engineered babies. So, because all of us have those kind of limitations, and I would like to share with you my personal experience. My son has Down syndrome and he is 43. He is one of the finest human beings. If I had not brought him up, if he was not my son, I would have been deprived of so much rich learning which has happened. Not only that, you see, I have seen so much potential. Earlier people were rejecting them, and by rejecting, and not only Down syndrome, whether with autism or physical or cerebral palsy and so on, I have seen such courage in them. And then we are deprived, we are saying the society, the parents will have to, undergo suffering. What kind of suffering? We cannot prevent all sources of suffering. So, my plea still remains, it's a very critical issue and very carefully it has to be observed. Otherwise, what happens is, you see, when we are saying a person or fetus with abnormality also can be aborted within 24 weeks, what kind of a value we are placing on the millions of people who are living with various kind of deformities? So we are saying their life is worthless? Whose life is worthy and whose is not? If if I wasn't born in this world, the world would not have been poorer than what it is.
Yeah.
So we cannot take these kind of, we have to be very careful in taking these kind of positions. So let everybody live. We should provide the necessary support, necessary opportunities like everyone, irrespective of caste, class, irrespective of the economic status, irrespective of who is doing very well and who is not doing so well, etc. So the society cannot, yes, if it hampers the survival of the mother or the child, it's a very valid argument.
Dr. Sharma, you wanted to make a point?
Yeah, so my only thing is, ma'am, very well taken. I think that's a very kind of compassionate view to things, and I think it's like very good. My only point is that Again and again, I'm saying the same thing. As a doctor, we come across such difficulties in our day-to-day practice. And that's the reason I am again and again reasserting. And if you feel like, you're saying that everybody will go for abortion, but just remember that each couple that comes to us, we know that for abortion, they go through hell. It's not easy on the conscience of any parent.
Yes, for doctors, it's an ethical dilemma, because whose life do you choose?
Yes, so it's not, and also that is number one point that I would say that, if you actually do from 20 to 24 weeks, it's not as if you are opening the floodgates or something. For every abortion, every parent for an abnormal child goes through hell, right? And it's a difficult decision for them too. My second point is that then why are we having the law till 20 weeks? Then ban abortion, don't allow abortion, right? If you are allowing till 20, allow till 24. That's the only thing for larger benefit, nothing else. I'm just saying if we are having till 20 weeks, have till 24 weeks. Okay, because whatever is happening till 20 weeks will happen till 24 weeks without affecting the life of the mother, but to the benefit of many, many more couples. That's the only thing.
Okay. So I may be letting an elephant in the room, Sanskriti, by asking this, but there are concerns that by amending the law, you sort of give a window, open that window for sex election abortions, which are, expected to increase once this law is amended. Do you agree with this?
See, the concern is well taken, but the answer to that concern is not to curtail the rights of the women, but the answer is that you implement your 94 law, which deals with pre-diagnostic technologies. You implement the law properly. But because you have failed to implement the law properly, that does not mean you are going to curtail the reproductive choice. I mean, these are serious issues. So you can't just wish away by saying that this is going to lead to more female feticide. You implement your law.
But in a country like ours, where, abortion and female infanticide are, kind of connected, because even today we know for a fact that in our society there will be women who will be having a preference for one particular gender, and that's the male child. So in a situation like that, what is the solution, Mr. Agarwal?
Awareness.
How do you stop the sex election
awareness
abortions?
And education. And slowly, people are moving away from this kind of a mindset. Even in rural areas, now things are changing and changing very fast. Earlier, everybody used to think that they should have at least one male child and maybe one or two female child kind of thing. Now, these things are undergoing a sea change, and it requires huge education, huge awareness, and huge facilities at the doorstep. We got to create good facilities. You are talking about sonography. You go to a village, you will not have the facility of sonography. How will that girl know whether she is pregnant, not pregnant, whether she is carrying a defective child or not? It's very difficult. So our laws have to be very, very simple and liberal, and a lot of flexibility has to be given. And the flexibility has to be given to the person concerned rather than giving to the law enforcement agencies or to the society.
Your viewpoint on this particular concern, because if the law is amended, remember we are getting into troubled waters. Under 12 weeks, the rate of abortions are going to increase.
So first of all, I would like to say medically that sex can be very well determined before 20 weeks. Okay? By ultrasound, you can very well determine the sex before 20 weeks. So if we feel 20 or 24, the only solution to female feticide is when the birth of a girl is not considered as bad news, right? When the girls are respected,
absolutely,
right? That is the only solution for female feticide. So making this law, not making it 24, or thinking that this is going to see, if they are doing it for female feticide, they will do it at 22 in an unsafe manner.
Yes.
Okay, so that is not the solution. The solution is that the girl child should come up, right? It says that, it's a girl are the 3 most deadliest word for a family, right? So when that will change, female feticide will change. So rest of it, these acts, these laws, make it 20, make it 24, it will not change. That's my view on it.
Let's go back to the audience again. डॉक्टर शर्मा ने जो कहा कि लॉ चेंज करें या ना करें, अगर किसी ने ये सोच लिया है कि हमें गर्ल चाइल्ड नहीं चाहिए तो वो लॉफुली अनलॉफुली कर लेंगे, पर अगर हम कानून में परिवर्तन कर देते हैं और ये लीगलाइज कर देते हैं कि अंडर 20 वीक्स या अंडर 24 वीक्स आप अबॉर्ट कर सकते हैं सर्टन कंडीशंस के साथ, तो क्या आपको लगता है कि ये जो सेक्स सिलेक्शन है वो लोग ज़्यादा करेंगे और ये डिसीजन उनके लिए लेना आसान होगा कि हमें फीमेल चाइल्ड चाहिए या नहीं चाहिए?
उनके लिए आसान हो जाएगा, ये नहीं होना चाहिए। मतलब जो सेक्स के लिए मतलब फीमेल मेल का अगर पता चल जाएगा तो कोई भी फीमेल को कोई चाहेगा ही नहीं, बच्ची को चाहेगा ही नहीं।
ये तो कानून में बदलाव, मेरा नाम मैगदिल मैरिन है, कानून में ये बदलाव नहीं आना चाहिए। जेंडर के बात जो आप कह रहे हैं, डॉक्टर बात कर रही हैं, अगर उनको पता चल जाता है तो सच बात है कि जैसे मैडम कह रही हैं कि फीमेल को तो कोई सामने लाएगा ही नहीं, फिर वो कॉक में ही मार दिया जाएगा, है ना, रेशियो भी बढ़ेगा और कॉक में ही मार दिया जाएगा।
What is the solution to these concerns that the women are raising?
बढ़ेगा ये तो नज़र आ रहा है, अगर उसमें से बहुत फर्म कुछ उसके क्लॉजेस नहीं लगेंगे, बट मुझे तो ये लग रहा है कि women empowerment through education, through certain kind of legal rights, जितने हैं उससे भी कुछ और एरियाज़ में लीगल राइट्स ही हैं, एंड इट शुड बी लाइक जैसे पल्स पोलियो का था, उस तरीके की मास अवेयरनेस की ज़रूरत है कि जिसमें इस तरीके की चीज़ों से मुक्त हुआ जा सके। एंड एक और भी चीज़ है, मैं ये भी देखती हूँ कि बहुत सारी सिचुएशंस में क्योंकि सिक्योरिटी ओल्ड एज में a male child is supposed to look after the parents, या उस तरीके का एक unsaid kind of assumption है, उसमें भी कुछ ऐसे बदलाव होने चाहिए। The girls also should be equally responsible for their aging parents as a boy is, as a son is. So एक बहुत mass education awareness होनी चाहिए, उससे ये चीज़ें जाएंगी। अब धीरे धीरे जैसे जैसे लड़कियों को अपॉर्चुनिटी मिल रही है, सोसाइटी देख रही है कि क्या फ़र्क पड़ता है ज़िंदगी में, बट अभी सब तक पहुंचने के लिए टाइम बहुत लगेगा।
जैसे कि मैम ने बोला कि अमेंडमेंट होगा तो लोग मतलब जेंडर चेक करके वो ज़्यादा होगा, लेकिन मैम जैसे कि ये लॉ है ये बहुत पुराना है, तो अब जो है जैसे लिव इन रिलेशनशिप है अब लीगल है जो कि पहले नहीं था, तो अमेंडमेंट तो होने ही चाहिए लॉ में क्योंकि वो ऑलरेडी बहुत पुराना है। जैसे कि मैम ने बोला कि लॉ सोसाइटी को चेंज नहीं करती, सोसाइटी लॉ को चेंज करती है। तो जब सोसाइटी चेंज हो रही है, काफ़ी चीज़ें चेंज हो चुकी हैं, कुछ चेंज हो रही हैं, तो लॉ भी अमेंडमेंट होना ज़रूरी है, ये मेरी ओपिनियन है।
हाय, दिस इज सुरेंद्र। एक्चुअली मैम ने जो डिस्कस किया अभी बात हुई, तो मैं ये कहना चाहता हूँ दिस इज़ ओनली फॉर द मैरिड वुमेन। जो चॉइस की बात है, जब पेरेंट्स उसके चॉइस करेंगे, हस्बैंड एंड वाइफ डिस्कस कर सकते हैं, चॉइस कर सकते हैं, और लड़का चाहिए लड़की चाहिए डिसाइड करते हैं सोशल में। व्हाट इज द प्रोविजन फॉर द अनमैरिड वुमेन? आई वांट टू दिस नो।
ओके, तो मैम यू आर सेइंग कि ये अगर लॉ में परिवर्तन अगर हो जाता है कि 20 हफ्ते से बढ़ाकर इसको अगर हम 24 वीक्स कर देते हैं, तो उसकी वजह से बहुत सारे लोग बाग प्रेरित होंगे कि वो जो गर्ल चाइल्ड है उसको अबॉर्ट करा लें,
उनके लिए आसान
हो जाएगा। आसान तो ज़रूर हो जाएगा, लेकिन अल्टीमेटली ये डिपेंड करता है एजुकेशन से। आप जहाँ भी रहते होंगे, जिस सोसाइटी में रहते होंगे, जिस गांव में रहते होंगे, शहर में रहते होंगे, इसमें कोई डाउट नहीं होना चाहिए कि ओवर अ पीरियड ऑफ टाइम एंड स्पेशली इन लास्ट 5 years जो हमारा एक माइंड सेट था अबाउट द गर्ल चाइल्ड, वो बहुत परिवर्तन आ गया उसमें। एंड इसी को हमें लगा था, जैसे आपने कहा कि एक मिशन होना चाहिए लाइक पल्स पोलियो की तरह से, एब्सोल्युटली देयर इज नो डाउट अबाउट इट। लेकिन अगर हम लॉ को चेंज नहीं करेंगे आवश्यकता के अनुसार, विल गेट फॉसिलाइज्ड। वी गॉट टू चेंज विद टाइम, एंड इफ वी डू नॉट चेंज विद टाइम विल गेट फॉसिलाइज्ड, and that will be counterproductive. We need to change with time, and as science has progressed, अगर 20 से 24 हफ्ते कर देते हैं, there is no problem at all whatsoever. And ultimately that call has to be taken by the concerned person, concerned mother. And I entirely agree with you also कि ये जो प्रॉब्लम है सेक्स डिटर्मिनेशन की, that comes when a person is married. अगर अनमैरिड है तो ये क्वेश्चन ही नहीं है बात।
True.
So at least उन लोगों को तो फायदा होगा जो अनमैरिड है.
Sanskriti, one critical aspect related to this very concern is that in a country like India, where we fight for the right to choice for women, we also have to understand the fact it is not only the woman who is going to exercise that right to choice. It is in a way giving that right to the husband, to the mother-in-law, to the extended family, to the society to a large extent. So, we're in a situation जहाँ सिर्फ एक औरत को ये डिसीजन लेने का अधिकार की हम मांग कर रहे हैं, वहाँ पर ये सिर्फ उसका अधिकार नहीं होगा. It will be exercised by a lot of other people associated with that woman. So how do kind of check that?
See, firstly, I disagree with the fact that the husband or the in-laws, they have a say in this matter. All right, up informally discuss karke, it's all right, you discuss, it's all right. But the ultimate choice is of the woman. She is the one who has to undergo these massive physical changes, mental changes.
Yes.
And also there are other socio-economic aspects to it. And she is the one who has to undergo all this. So it's the woman and woman alone and no other stakeholder involved in this decision-making process.
So it's a systematic change that we are calling for. But doctor, there are situations, there are cases wherein the doctors, they are supposed to take a decision. They will ask the woman to consult her family, call in the husband, and then the husband decides. So what role should the doctors be playing in such a situation like this?
No, so we are very sure about it. What we follow is called a non-directive counseling.
Okay.
Right? We give them, it's like a platter. We tell them, you keep this child, आप इस बच्चे को रखो, तो इसमें ये प्रॉब्लम है, इस बच्चे के बाद पैदा होने के बाद इसको इतनी सर्जरी करनी पड़ेगी और सर्जरी के बाद इसका सर्वाइवल ये है. We tell them numbers. है ना. अब वो ज़माना गया कि डॉक्टर भगवान है, आप डिसाइड करो हमारे लिए. We don't do that. Right? हम बस उनको ये बताते हैं that your बच्चा has this condition. Okay. उसके बाद इसका ये बचेगा कि नहीं बचेगा. ठीक है. अभी 4 days back there was a condition of जिसमें दोनों किडनियां नहीं बनी थी. राइट. सो उसमें हम ये बताएंगे कि आपका बच्चा जो है बिना सपोर्ट के, बिना सहायता के जिंदा नहीं रह सकता. ठीक. राइट. बट दिस वी टेल टू द मदर एंड द फादर एंड जनरली वी सी दैट, मतलब देखो हम डे इन एंड डे आउट व्हेन वी हैंडल सच पेशेंट्स एंड कपल्स, सो इट्स जनरली अ कंबाइंड डिसीजन and we don't see too much of a, especially when it comes to a fetal abnormality or something like that, the whole family takes a decision together, right? But yes, I agree with you that a woman cannot function alone, right? And जो भी decision होता है, it's a complete combined family decision. So you are in a way kind of empowering the family, the husband and the mother-in-law to take a decision on her behalf. But something that you are doing for the sake of the mother, eventually, because it is she who's going to be affected most. So I think, yes, we need to look into it, but in practice, in day-to-day practice, especially when you come across fetal abnormalities, I think most of them are in concord.
All right, so the decision should lie solely with the woman. All our panelists have had varying opinions. We've also had points of views from our audience members. While most of us agree that, the cap must be raised from 20 to 24 weeks. Perhaps that could solve a lot of problems that women are facing today. But there is also need for checks and balances. So in this ethical dilemma, while you give the right to choice to one section, we should not be taking away the right to life from the other particular, the unborn child that we are talking about in this case. Thank you to all our panelists for joining us on the show and putting forth their perspective. Thank you also to the audience for helping us build it into a very healthy discussion. So it's a wrap from us on this edition of The Pulse this week. We'll be back same time next week with a different topic and a different set of guests. Until then, take good care of yourself. It's a goodbye from all of us.